Hi, today we're going to talk about the law as well as the differences in legal issues and how those impact your ability to manage employees or your situation as an employee. More specifically, we are going to talk about first differences in legal systems and how those play out in your international business arena. We are going to also talk about the supranational organizations that may have an effect on what you can do as a manager or as an employee. We'll talk about a few special organizations and treaties that may have an impact on an organization that you may work for or manage, as well as we will talk a little bit about the ethical issues that are not always spelled out as laws, but may still have an impact on what you can and cannot do as an employer or an employee, and often those actually have a legal recourse. So first, about the different legal systems. Those of you who took my Management 301 course probably know that there are three major legal systems, and those who don't will know after this lecture. So we have countries with a so-called common law, civil law, and religious law. Common law countries, well, let's get first to the easy one, the religious law. There are some countries, like, for example, some countries in the Middle East that rely on religious texts, and those provide the legal foundation for the country. For example, it would be the Quran in the Saudi Arabia, or apparently some religious texts play a huge role in the legal system of Israel, so the Jewish law. There are probably other countries in the world that also rely heavily on the religious writings or texts in terms of the legal system, but the Middle East would be probably the best example. And so basically the religious book that the nation respects as the one book would then pretty much provide the foundation for all kinds of areas of life, including the legal system. Now, the more difficult types of systems that many people often cannot differentiate are the common law and the civil law. And let me talk about them one by one. First, I provide here links to wonderful Wikipedia articles about these systems. I know many people frown upon Wikipedia as a source of information, but if you need a nice overview, it actually is a very good source. You cannot perhaps cite Wikipedia as a source in your papers. You should actually go to the real source. But if you need a summary, I recommend reading those articles. Theocratic or religious law is actually a fascinating topic. I mean, very, very interesting. Again, those of you who took my Management 301 course, we've discussed things like, for example, how you can lend money or borrow money, and how that would be very different in some Muslim countries, because the Quran has very specific prescriptions as to how, for example, interest can or cannot be charged, and all kinds of other issues. Again, some religious texts may also talk about how you can treat your employees and your employers, and so those again may be very, if not very different from your common standards, then at least may have some interesting aspects that sometimes you may not be used to or expect. But now let's talk about the difference between the common law and civil law countries. Well, first, common law countries are the countries usually that have some ties to the British Empire. So it would be the Britain itself, and then the former British colonies, like, for example, the United States and Canada and Australia and New Zealand and some other territories. The civil law countries are pretty much everything else, or all the other countries, but the European Union would be a very good example of the region where the civil law usually is the standard. And so the big differences would be obviously that the civil law countries, they have the laws spelled out in a text. So the parliament or whatever organization they have there that is the legislative organ, so they would get together, they would think about the possible, let's say, crimes or situations, and they would write laws about those situations. So what needs to be done in each specific case, and what is the recourse if the law is broken. And it would be literally a book, maybe bigger than this one, but it would be just a book. And so if you have any questions about the law, you open the book, you find the corresponding chapter, and you read what the law says about it in that book. And so when, for example, the law is broken and the court is presiding and looking at the case, the judge would be referring to that specific book when deciding if the law was actually broken, and if so, what the sentence should be. In the common law countries, the law is basically the precedent. So the logic here is that if somebody at some point in the history of the country, or jurisdiction I should say, committed the same act, for example, broke the law in the same way, then whatever the sentence was for that previous person or case or organization, that's exactly the same type of punishment, or that's the same type of solution that should be applied to the case in question. So when something happens, the lawyers and the judge should basically muddle through the previous cases that are similar, find the ones that are very similar to the one that we have at hand here, and then rule based on those previous precedents, trying to be as consistent as possible with the previous similar cases. So obviously that makes the two systems very different. So the common law system that is apparently created to be more fair in the sense that everybody should be punished the same way as everybody else before him or her was punished for the same acts or the same crimes. And so that makes it consistent, and therefore they believe that makes it fair. The civil law system believes that, well, to enforce consistency, we should have one book, and that would be one standard for everyone. So it doesn't matter even if someone had a similar case before, and even if that case was ruled, let's say, wrong. So it doesn't matter whatever the judge decided in the past. We have the book that says what needs to be done, and that's what we use. So as you can imagine, the civil law system is much simpler. So you have one book, and that's all you need to know. And obviously I have a different actually, incidentally, I have a killer history book here, so not that remote from the law. So in the common law countries, the system is much more complicated because you have tons and tons of previous cases, literally maybe hundreds of thousands. You have to go through them to find the similar ones. Then you find the similar ones, and turns out that sometimes, for some reason, the rulings were somewhat different. And then you also find that there are differences across jurisdictions, and there are all kinds of overlaps and interrelations among those jurisdictions and cases, and so it becomes very, very complicated. So as a result, a lawyer in a common law country has to be a person who is very good at going through tons of documents, finding the ones that are relevant to the case, and arguing why these and those laws should be taken into account as precedent when making a decision on this particular case. In the civil law countries, it's much simpler. So you basically read your textbook or handbook, and that's all you need to know. So as a result, the options in the common law countries tend to be very long. The options, basically, that's the decision of the court. So they would make or contain tons of references to the previous cases. They would explain why those are relevant cases, so they would be literally pages and pages and pages. In the civil law countries, the options are short, as per Chapter 5, Section 3, Paragraph 5, this is what we had, and this is the decision. So one page, maybe sometimes even less. The judges obviously play then a huge role in the common law countries. So if in the United States, for example, or Canada, a judge is usually a person with a lot of experience, lots of credibility, an older person, right? So, but in the civil law countries, the judge often is basically a recent graduate. You can literally go and get a degree as a judge, graduate, and get a job as a judge right out of college. Because again, it's not about being wise or not about being experienced. It's about just knowing what's in the law book, and that's pretty much all you need. Then again, because of the complications or complexity, because of the complexity of the common law system, the jury of peers plays an important role in those countries. So obviously, again, you want to have the jurors, because it's so difficult, so complicated. You don't want to trust that one decision to one single person. In civil law countries, often there are even no jury of peers, and even if they are there, they may not be as a critical player in the hearing as in the common law countries. So those are kind of the big differences, and so remember that depending on which country you operate your business in, you may be, if something goes wrong, you may be subjected to two very different systems. Again, if as a plaintiff or perhaps as a defendant. So hopefully you will never have to experience that, but if you are going to experience that, at least you will know what the differences are. Now, the laws themselves don't come from anywhere or from nowhere. So there are all kinds of organizations that may shape those laws. And so there are some organizations or laws that are national, and those are the majority of the laws. Usually, yes, the laws differ from a country to country, but are consistent within countries. But then obviously you have all kinds of territorial laws, like for example in the United States, there are different laws in different states. And so even though this is one country, but often the laws, especially labor laws, are drastically different. And then you also have supranational laws, like you have all kinds of international agreements, like for example NAFTA that you have in the United States. So that agreement shapes to a large degree the laws that in part, for example, may regulate international business, trade, and labor movement and labor relations. Those also can be all kinds of treaties and agreements with supranational organizations like the United Nations, like for example NATO, World Bank, and so on and so on. So what are those organizations that may affect your laws about international business and labor? Well, as mentioned, those would be the International Labor Organization, a very powerful one, United Nations, OECD, World Bank, IMF, and as well as some regional blocks and treaties that may have an impact on your national laws. So let's talk about them one by one. First, International Labor Organization. Most of you probably don't know that it exists and what it does, but when you look at the map here in the lower corner of the slide, you will see that pretty much every single country on this planet are a member or abide by the laws or rules of the International Labor Organization. And so what these guys basically do is they develop guidelines or rules, in a sense, that they suggest that the nation states adopt in their legislative base. And so usually those would be things like rules about the freedom of association. So we're basically talking here about unions. So freedom or the right of the employees to form a union and bargain collectively. Then obviously all the kinds of laws related to discrimination, to child labor, forced labor, occupational safety and health. Rules that may regulate how employees are treated when there is a drastic reduction in the employee number. So for example, layoffs, factory closures, that kind of stuff. Grievances and disputes, as well as audit of employment practices. So again, it doesn't mean that this organization makes the laws for the countries. It just means that it develops the guidelines, and then the nations basically sign up to follow those guidelines and try to form their legislative basis in such a way that they are in sync, they conform to the rules and regulations suggested by the International Labor Organization. So if you sign a membership, or if you become a member of the organization, if your country becomes a member of the organization, you basically take on a responsibility to change your law or modify your law in such a way that you follow these rules and guidelines suggested by the ILO. Then obviously you have the United Nations organization, and this one is not really about the international business or about international law or labor law, but still there are some things that the United Nations may regulate or have relations to that actually would impact how you manage, for example, your employees. So it would be again mainly things related to the rights, to discrimination, to basically all those, let's call them the soft core laws that deal with international business and regulations. So there would be no really prescriptions for example, trade or economic policies, or at least not directly, but there will be all kinds of policies and prescriptions related to treating people, and so those sometimes have a major impact on the labor laws. Then you have OECD, so the Organization for Economic Cooperation and Development. This is basically an organization or a union in some form, or an agreement among the developed countries. So those are the rich countries that cooperate together to survive in a globalized world. So it's mainly Europe, North America, Australia, Japan, and a few other highly developed countries. South Korea, Chile, and Mexico are members, but not just recently joined, and so usually, or sometimes they're not full-fledged members. But actually, I believe now they are actually more recent but full-fledged members of the organization. And again, here they mainly talk about or mainly deal with economic policies in general, but again, many aspects of those policies may have an impact on labor laws. So on whom you can hire, how, and all those kinds of things. Again, they tend to favor and advocate freedom of labor movement, non-discrimination, obviously, and all those other kind of good policies that a free and civil society should adopt. Then we have the World Bank and the International Monetary Funds. Again, these organizations are more about the fiscal policies, but sometimes those may have consequences for the international labor laws and relations. And again, when you look at the membership of these countries, so unlike the United Nations or ILO, where pretty much the entire world is a member of, the IMF and World Bank operate in most countries, but the different countries have different sorts of relationships. So some are members, some are kind of clients. But again, in a sense, pretty much every country at some point deals in one way or another with the World Bank. And so, since these organizations primarily deal with the fiscal policies, they usually have an impact on, for example, things like wages, unemployment, reforms related to wages and unemployment. So usually they wouldn't really prescribe policies, but if you want to borrow money from the IMF, then they may tell you, well, we'll give you the money, but only under the condition that you will, for example, do this or do that, don't do this or that with respect to, for example, your unemployment and wages. And so, being from Ukraine, I know that, for example, Ukraine has borrowed money from the IMF on numerous occasions, and in many cases the conditions would be, all right, we'll give you the money, but for example, you have to change your policies with respect to the pension payments, or for example, you have to change your policies with respect to the wages and salaries compensation of the state employees. Now, the World Trade Organization, again, the same thing. It mainly deals with the trade between the nations or among the nations. So it would be mainly about the import tariffs, anti-dumping laws, that kind of stuff. But again, in many cases, those may have implications for the labor policies. But usually the World Trade Organization simply defers to the ILO, International Labor Organization, and so they would usually say that if you become a member of the World Trade Organization, please do follow the ILO's guidelines on the labor laws. And again, if you look at the map of the world, you will see that pretty much the entire world is in some way related to the World Trade Organization. Just some of the countries are members, some are observers, and then some are represented as a bloc, like for example the EU, and then there are a few countries in Africa and the Middle East that are not members of the World Trade Organization, plus the North Korea. So those are the only really exceptions. Finally, the European Union. Well, this organization has a major impact on labor relations and laws within the bloc. So as you know, the members of the European Union impose no restrictions on movement of labor. And so if you're from one of these countries, denoted yellow on the map, you would be able to go to any country within the bloc and work there, just like you can move from one state in the United States to another. And then obviously there are all kinds of other laws and regulations that are common to the European Union and that are kind of, I don't want to use the word pushed, suggested from the top, like the European Parliament, the European Commission, to the member states that again regulate everything from discrimination or anti-discrimination, wages, and all those other policies that relate to the employment. So there are all kinds of things. Please note also that even though pretty much all of the European continent is part of the EU, but some countries are notably exceptions. Like for example, Switzerland, right here in the very heart of the European Union, is actually not a member of the European Union. So they still have their own currency and they still have their own regulations. So, for example, being from Germany, you cannot simply go to Switzerland and work there without applying for a work permit. Same thing with Norway, and then you cannot see here on the map, but Liechtenstein, it's a very tiny country right by Switzerland there, so they are not members of the Union. Same thing with, for example, Iceland. Now the UK, for example, they still use their own currency, as do, by the way, many new members of the European Union. But other than that, they do follow the same labor regulations and laws as the rest of the Union. And the organization that has a major impact on the laws in the United States, NAFTA, so North American Free Trade Agreement. Again, this organization is primarily about free trade, so it's about import tariffs, all those kinds of things. But within NAFTA, there are a number of rules that apply to the labor movement as well as labor laws. Excuse me. So, for example, while you go from one country of NAFTA to another, for example, from Mexico to the United States or from the United States to Mexico, and work there, you still would need to apply for a work visa or a work permit, but it would be easier to get it if you come from within that block than from outside the block. So, for example, if you came to work in the United States from Germany, the procedure for you would be much more complicated to get the work visa than if you come from Canada. Even if you come from Canada, you still need to apply for the visa, for the work permit, which, again, you don't necessarily need the stamp, the visa stamp in your passport, but you would still have to apply for that visa status, like, for example, TN or O1 or whatever that is. So you would still have to get a piece of paper that says that you have that employment status as a foreigner, and so it's just easier for you to get it if you are from within NAFTA. But it's not an automatic thing, and you cannot just simply move within the block as the European, for example, citizens can do within their block within EU. So if an American wanted to work in Canada, it wouldn't be just, just cross the border and apply for a job. You would have to apply as basically as an immigrant for a work permit. Now, talking about international labor law, let's discuss the areas where those laws differ the most, or areas that matter most when you do business internationally. So if you decided to go and work in a different country, or if you decided to employ people from different countries, so these are the things that will probably be the biggest hassle for you. These are the things that will differ most from a country to country, and things that you will have to deal with as an international manager or employee. And right before I even get into those different areas, I'm going to tell you that it's very, very complicated. So like that bowl of spaghetti. So there are so many different things. I mean, it seems like it's easy. In movies, for example, I was watching just the other day, I was watching the movie called Just Visiting, about two guys who came here from the 12th century, time travel, and so they came to the modern time United States, and then eventually one of them decided to stay in the United States. Or other movies of that kind, like Hercules, played by Arnold Schwarzenegger. The guy travels to the United States from ancient Greece and basically does well here. Not so simple. I mean, the labor laws, somebody will at some point come to you and say, well, could you please show me your papers, immigration papers, and are you sure you can work here? And chances are those dudes from the 12th century, they wouldn't be allowed to work here. So it's not so easy and not so simple. So let's talk about each of those one by one. So first, the work visa and permits. If you go from one country to another and want to work there, or if you want to hire people from a different country to work for you here, chances are you will have to deal with the work visa and permit issues. So virtually always you need a visa, a work visa, or a work permit, and sometimes getting those is very, very difficult. Even within the US and Canada, for example, you would still have to apply for a work visa. Even though it looks like it's very easy to go from one country to another, actually, well, it is not too difficult, but you still have to apply for a work permit as an immigrant. For example, I have a Canadian passport, and yes, I work in the United States, but I still had to apply for a visa, and first I had what they call a TN visa, which is a trade NAFTA type of visa, so a specific type of visa reserved for Americans working in Canada, Canadians working in the US, as well as Mexico. And so it's fairly easy to get it, but then again, there is a limited list of professions that that visa applies to, and you still have to apply for it, and then you have to renew it. And then on top of that, it's what they call an employer-specific visa, which means that even when you get it, you wouldn't be allowed to have multiple jobs at the same time. And if you decided to change your employer, you would have to apply for a new visa or renew it with a different employer. Very inconvenient, by the way. For example, if you decided to hire me to mow your lawn or to maybe tutor you in math, for example, I wouldn't be able to accept your employment offer because I have an employer-specific visa. In fact, now I have what they call an O1 visa. That's individuals with exceptional skills and experiences in science, arts, and sports, I believe. And so it's a very unique, very privileged type of visa, but even that one is an employer-specific one. So I'm not allowed to, for example, also teach classes at a different university at the same time. Same thing if you go to, for example, Canada. You can travel there, no problem, but if you decided to take a job there, it would have to be the same basically procedure. You will have an easier time again than someone coming from outside NAFTA, but you would still have to, it would be much more complicated than simply going, for example, from North Carolina to Virginia and taking a job there. EU members, so citizens of the European Union, they can freely move from a country to country, but again, they would still have to deal with a number of other issues, like, for example, taxation, like, for example, differences in currencies. So if you go, for example, from Poland to Germany, yes, you can go and take a job, but you would still be paid in a different currency. Poland still uses zlotys, and Germany has euros. So there would be still some little things that you would have to take into account. Now, as I said, in most of the cases, you would have to apply for a work permit or a visa. And so the issues here would be the following. First, the big question would be if your visa is so-called dual intent or not dual intent. In the United States, that means that a dual intent visa allows you not only to work, but also apply for a permanent status. So for the green card and eventually the citizenship. So if you, for example, have H-1B visa or O-1, you can apply for citizenship eventually. But for example, if you work in that TN visa, the one specifically designed for NAFTA, it's not a dual intent visa, so you can work in that status, but you cannot apply for the green card and you cannot apply for the citizenship. Same thing applies, for example, to the student visas, F1 or J1, so you can reside in the country and study on that, in that status or on that visa, but you wouldn't be allowed to apply for the green card, so you can be here for many years and still not have the, the kind of the permanent status. So obviously then also all work permits and visas are term specific and you would have to renew them, and that's a major inconvenience. Like in my case, my TN was last time issued or renewed for 3 years. Eventually it will expire, and you apply for the renewal, but it's never been a problem before, but who knows, sometimes it may be an issue, and that creates this additional stress and uncertainty. And then obviously, as I said, those visas tend to be employer specific, so which means if you apply and get a job from XYZ company, and at the same time somebody wants you to also do some work for another company, or you decide to switch employers, you would basically have to go through the employment permit again, anew. And so again, that's very complicated, very inconvenient. And then obviously the family member employment rights, very big thing. Like for example, even though I have this kind of privileged O1 visa in the United States, my family members are in what they call O3 status, so dependents of O1, and they're not allowed to work. So they are allowed to study but not to work. And so basically that means as long as they stay in the United States, I'm bound to live on one salary because my wife is not allowed to work. And that's a major inconvenience, obviously. And then taxes is a big deal. So you may, for example, as an American citizen, no matter where you work and where you reside, you would still have to pay taxes in the United States. And yes, there are treaties between the United States and other countries, like for example Canada, that may regulate and simplify this issue. But if there is no treaty, or even if there is a treaty, you would still have to report back to the United States what you made, where you paid the taxes. It just, you may be exempt from double taxation. So, and then obviously benefit transferability. So all your pension plans, health insurance plans, in-state, out-of-state eligibility, those again would be an issue when you move from one country to another or hire people from one country to another. Again, if we talk about the OECD, so the developed countries, usually there would be some sorts of agreements, and those would be in some way transferable, but not always, and then usually not when you go from countries that have not signed any types of agreements in those areas. So whatever money, for example, you may have in your pension fund in one country may not be transferred automatically to a new fund in a new country. Your health insurance may not be the continuation may not be guaranteed. And then even within the United States, by the way, if you move from one state to another, your spouse or you personally may not be allowed for in-state tuition in that new territory, usually for a year at least, and sometimes even longer. So, and then obviously if you go to a whole new country, you may not be eligible for in-state right away, or not even ever. So some countries are very, very protective in those areas. Then you have data privacy. Again, in different countries, the laws are very different about that, and there are huge inconsistencies. So, for example, in some countries, your private data related to your employment would be very, very protected. Nobody can ask how much you make, where you work or worked before, all those kinds of things. And in some countries, that is public information. The state can access that information, and sometimes even citizens can access that information. So your employment history, your previous record, in all areas, including criminal record, income level in general, income level in particular periods or in particular jobs, health information, all that kind of, information about decisions to hire and fire, all those kinds of things. For example, in the United States, it's fairly protected, but some things are still, like for example, your employer may request your right to access your criminal records. And again, it would have to be, you would have to be informed about that decision by the employer to access your records. But in some countries, they can do it without even telling you, or they have the right to do it. Then, for example, in the United States, one thing that has to be made public is if you, for example, apply for a job, or if you are fired, or apply for school for that matter, you are usually allowed to request from the employer or the institution, the school, information as to why you were or were not hired or accepted or fired. And again, in different countries, the regulations may be very different, so it may be very easy for you as an employer or employee to access that information, or it may be impossible for you as an employer or employee to access that information. So very different from country to country. Then anti-discrimination. Oh, this is a very interesting topic. First, the rules and laws about discrimination are very, very different from country to country. In some countries, they are very strict. Like, for example, in the United States, discrimination is a big, big deal. In some countries, the rules may not be even existent, and they may not even if they exist, they may not be applied. And so what you may be used to in the United States may not work in a different country. So let's talk about some of those most interesting issues. So as you may know, in the United States, you cannot discriminate based on race, ethnicity, gender, religion, age, sexual orientation, as well as political views, disability, person's appearance, immigrant status, and so on. Well, actually not so on, that's it. So, but sometimes there are notable exceptions even within the United States, and again, some of these may not be a area where discrimination is prohibited in other countries. So first, in the United States, there may be some exceptions. So for example, if you are, let me put it this way, you as an employer can make a case and apply for so-called bona fide occupational qualification exemption. So you can make a case that for a particular job you may need to have a person of a specific race or ethnicity or gender, religion, age, all of those. For example, if you are shooting a movie and your actor or star or character is, let's say, an African American, then you may be able to discriminate and say, well, for this role I'm only going to hire an African American because, a white person, for example, doesn't fit the role. And so it is, in a sense, discrimination, but it would be allowed to discriminate in this case. Or for example, let's say if you are a religious institution and you need to hire let's say a pastor or a rabbi, obviously again you may be able to make a case and say, well, I can only hire people of certain religion for this particular job. And again, if it's a pastor, it would be fairly easy to get that exemption. It would be fairly easy to prove that only a person who is, for example, a Catholic can take a job as a Catholic priest in a church. It would be a little bit more difficult to make, in fact, it may be even impossible to make the case that, for example, all employees of that church or of that, let's say, daycare that is operated by a Catholic church have to be Catholics. So it may be difficult or impossible to prove that, for example, I don't know, janitors or daycare providers like nannies in the daycare have to be also Catholic. So why not, for example, someone else? Then, for example, disability. You cannot discriminate against people with disabilities, or health cannot be a reason for discrimination. But again, if you are, let's say, a fire department or a police department, obviously firefighters may have to, you may have rules as to how physically fit they have to be, and there are actually usually very specific rules, like as to how fast you have to be able to run, or what kind of weight you have to be able to lift. And so if you are handicapped, chances are you will be denied a job as a firefighter for obvious reasons, and you basically will be discriminated against. So appearance is more difficult to deal with. But even there, again, if appearance is part of the job, like for example, if you want to be a model or if you want to be an actor, again, based on your appearance, you may be denied the job, and so that may be an issue. Immigrant status is tricky. On the one hand, it's still equal pay for equal work regardless of your immigrant status. But then again, the immigration laws may create all kinds of restrictions as to, where you as an immigrant can work, what kind of jobs you can take. And so in a sense that would be discrimination, but again, legally allowed. But then again, you go to a different country and those rights may not be protected, and so you may not be allowed to work because of your race, ethnicity, gender, all those kinds of things. In fact, in some countries, the laws may not be firmly enforced, and even though it may be not allowed to, for example, discriminate based on one's race or ethnicity, the employers may get very creative and find ways to discriminate against you without actually breaking the law. Like for example, in Germany, a couple of friends of mine complained that while it's illegal to discriminate against, for example, internationals, against immigrants, so you still are allowed not to hire people who don't have the permit, but let's say the person now became a citizen, so you can still discriminate, or some organizations allegedly discriminate by, for example, saying that the employee must be a native German speaker. And so while they don't really specifically say that it has to be a German, a German, but obviously most immigrants would have an accent, and so by imposing that restriction, you effectively can discriminate against people of non-German nationality, or at least people who are not locally born and raised and speak without an accent. And again, I suspect in Germany or other civilized countries like Germany, that's not really an issue, and I suspect most employers are more worried about your own abilities and wouldn't care about other things. But again, at least in principle, or there have been cases when such discrimination occurred, even though on paper it didn't look like discrimination. So, and then again, there are some countries, like for example Japan or other, that are notoriously, I don't want to use the word discriminating, but again, it would be extremely difficult, virtually impossible, for example, to get the permanent status, to get the citizenship status, and again, it probably will never be said explicitly, but they tend to greatly favor people of their own ethnicity, for example, Japanese. So foreigners often have their hard time. And then again, you go to a country like, for example, Ukraine, where, again, technically discrimination is prohibited, just like in the United States, but an employer may, for example, not hire you because you are older and you're approaching retirement, and they don't want to be liable or don't want to get you only for a few years. So, like, generally getting a job after you're 50 is virtually impossible. And while the law prohibits this form of discrimination, you may have a very difficult time proving anything. And so even if you know for sure that you've been discriminated against, you still will not be able to defend your rights in court, and it's almost impossible to actually get any sort of compensation or legal recourse. Now, harassment is another issue. In the United States, as you know, sexual harassment as well as other types of harassment like toxic environment, where you're constantly abused or bullied. So it's usually not tolerated in the United States, and usually you as an employee can sue your employer if something like this goes on, and there is a very good chance you will win if you have the proof that harassment did take place. It still does unfortunately take place, and it's not always easy to prove it because the people who abuse you are not dumb, and in many cases they wouldn't do it publicly, and so it's not always easy to collect the necessary evidence. But at least if the evidence exists, you will be protected. In other countries that may not be the case. And sexual harassment or some other stuff may not even be seen as a problem in some countries. So it may be, for you as an employee, no way to defend your rights. And so, more important, there are huge differences in perceptions. So the laws may be more or less the same, but the perceptions, the way people treat it, may be very different. So many things that would be outrageous in the United States to anyone, people would be like, whoa, that's too much. In some countries, they would say, what's the problem? He's just making you or giving you a compliment. So in some countries, for example, what we would call sexual harassment here would be just perceived as chivalry, as being, courteous to women. And we actually have that problem often in the X-Culture project. Again, those of you who took Management 301 and participated in X-Culture, you know what it is. But basically, we take people from different countries, put them in global virtual teams, and they work together on a business project for a semester. And so we often have problems when excessive attention from men from like Middle Eastern countries and sometimes Southern European countries or Latin American countries is pursued as perfectly fine and in fact even welcome there, because you as a man are expected to be courteous and nice to women, but our American female students often see that as too much, and they often complain to their professors saying, no, I don't want that kind of attention. That's not task related. I don't want to get like love notes from time to time or compliments. One maybe sometimes is okay, but if I get too many of those, that makes them uncomfortable. And we obviously don't have any specific laws that regulate every tiny little bit as what you can and cannot say. And so in many cases it is left up to the basically ethics standards or interpersonal relations. And again, those are sometimes very different from country to country, so the perceptions are different. And so what makes you uncomfortable here may be perfectly normal somewhere else. Now, the laws that regulate termination, so how you can fire employees or how you can be fired or laid off, again, those differ dramatically from a country to country, very, very much. Well, first, in the United States, for some reason, most people believe that as an employee, you have to give a 2-week notice, and if somebody tries to fire you, you have to be informed 2 weeks in advance. And I suspect a major role here played that movie 2-week notice, but no, in reality, 2 weeks, I'm not even sure where it came from. It's probably a commonly accepted ethical standard, but other than that, it has no legal basis, or at least not, generally. So, but in any case, the laws may regulate as to how much in advance you have to inform your employees about the upcoming termination or layoffs, severance packages, unemployment insurance, retirement packages, those kinds of things. And in the United States, generally, the employees have no real protection. So if I, as an employer, want to fire you, I don't have to give you any notice. I can fire you today at 3 p.m. And not even inform you a minute in advance. So unless obviously I'm trying to fire you for, let's say, for your race or sexual orientation, I cannot do that. But if I simply don't need your services anymore, I can just wait until Friday 5 p.m. and tell you a minute before the end of the working day that, sorry, I decided to lay you off, so please don't show up on Monday. I will still have to pay you up until the last minute, but I don't really have to, to be nice to you and pay you anything extra or inform you in advance. As a human being, I would do that, but the law does not require that I do that, so I obviously have the right to, it's an easy thing. In some countries it's not so easy. So in some countries you cannot just fire or lay off an employee, so there may be all kinds of regulations. So for example, in the European Union there tend to be huge protections of employees in that respect. So for example, just as an example, if you have an employee who makes $100,000 a year and has worked for 10 years for your company, so in the United States, generally if you decided to terminate that employee 5 p.m. Friday, just don't show up on Monday. That's it. You just pay up until that minute where the person was laid off, and that's it. Again, if the employer is nice, you may offer some sort of, compensation, extra compensation, or you may inform your employees in advance, but you don't have to do that, right? The state provides some safety net, so there is an unemployment insurance, and there may be other types of benefits or safety things that you get if there is a labor union. And usually if your company is unionized, then yes, the collective bargaining agreement may have very specific rules and all kinds of safety measures geared towards protecting the employees against termination and what happens with that. But if there is no union in the United States, the person is basically gone. And I know that most Americans don't like unions in general, and so I'm not a big fan of unions either, but that's when you are an employer, or when the case of, for example, layoff doesn't bother you. When you work for a company as an employee, you actually wish there was a union. So if you work for a unionized organization, generally your employer will not be able to take advantage of you, so there would be some sort of protection in place for you as an employee. So as an employer, you obviously want to have the freedom to run your business the way you want, but as an employee, you kind of wish there was a union in your organization, right? So unless there is a union, generally you will be fired no matter how long, or you can be fired no matter how long you worked for the organization and no matter how much you make. But then in other countries, like for example in Belgium, your severance package would be huge. Like for example, if you work for that much, you would get either a 14 months notice or you will get a 14-month pay. So if you are fired today without being informed in advance, you will receive a compensation for almost and a half year in advance. Or you would have to be informed about you being laid off almost 1.5 years in advance. I actually have a friend, a colleague, whose brother worked for a bank in France, and so that bank was acquired by another bank, and the new bank decided that the merged organization decided that they no longer need all those employees, and so they laid off a number of people, including the brother of my colleague. And so the guy got over a year extra compensation. So he was told, you're no longer needed, but the law requires that we pay you for, and it was around 14 months, so here is your money. And the guy found a new job within a week, but even though he did find a new job within a week, he still kept the money, so it actually worked out very, very well for him. So in the United States it wouldn't be the case, but if you decided to do business, for example, in Germany or Belgium or France for that matter, and you decided to get rid of some employees, it may be extremely expensive. Even in the United States, by the way, if you have a union and you decided to, for example, downsize, it may not be as easy, it may be costly. And as you know, for example, General Motors and some other Detroit area companies, many of which, in fact most of which are unionized, one of the major hassles for them is that the company is becoming too costly to honor all those collective bargaining agreement stipulations, but then getting rid of employees may not be easy, and so severance packages are huge, and many companies are not able to downsize when they need to, and I'm not sure if it's a good thing or a bad thing. I mean, obviously it's a bad thing if you're an employer. It's a good thing if you're an employee. For the country as a whole, on the one hand, obviously the businesses lose flexibility, and if you believe in free market economy, then it's kind of a bad thing. But on the other hand, that prevents kind of keeps unemployment down, because if companies were able to fire people right and left, then obviously that would only make the situation worse, would only aggravate the problem of unemployment. So when the economic crisis comes, you kind of wish that more companies in your country had some sort of labor unions, so that not so many people could be fired right away, because then you have more people still gainfully employed, paid, and so the crisis is not as deep, and so everybody kind of benefits. Though again, obviously, this is not an easy question. But anyway, going down the list, so for example, in Ireland, if you had a person who makes 100,000 K and worked for 10 years, the unemployment package would be, severance package would be 6.5 weeks of pay, or 6.5, in this case, not notice, just 6.5 weeks of pay. But it would be up to $25,000 maximum per year. So if you decided, for example, to simply hop from a job to a job every day and try to get that sort of compensation, it wouldn't be, the companies would be required to provide some sort of compensation, but there is a limit as to how much, and so you are protected to a sense, but not hugely protected. In Japan, it's a 30 days notice or pay, whatever your pay is. In Venezuela, it's 10 months. So as you can see, these are huge differences, from nothing in the United States to over a year in Belgium to something in between in other countries. And so keep that in mind when you apply for a job. Elsewhere, you may be more protected, or if you hire people elsewhere, you may not be able to get rid of them as easily as it would be in the United States. Intellectual property, again, same thing. Huge differences across country, and we did talk many times in Management 301 with respect intellectual property as copyright, as you stealing, for example, music or software, but it also applies to the labor laws. So, for example, there would be some differences in laws or rules as to who owns the ideas that the employee had while working for a company. So for example, if you work for, let's say, Google, right, and you have an idea, you invent something, and then you decide to go and work for a different company, there may be rules that allow the employer, for example, prevent you from using those ideas with a different employer or starting your own company. Or there may be rules that specifically says that you can do and transfer your ideas to a different employer. Usually you would have a contract, and that contract would usually stipulate all those little things, would actually explain what ideas or what things belong to you and what ideas or things don't belong to you. So if you came up with that idea using, for example, a company computer and company infrastructure, and that's what you were working as a company employee, you would normally not be allowed to take that idea with you to a different employer. But the contract itself, even though it does tell what can and cannot be done, the contract has to abide by the law. And so what can be put in that contract may be regulated by the law. And so sometimes there would be cases in the United States where the contract says A, B, C, but it turns out that those terms of the contract may violate the law itself. And so it's very important that you consult the law before you decide what you can and cannot put in the contract. Because again, as an employer, you want to protect yourself as much as possible. You want to be able to treat the employee to the advantage of the company, but again, sometimes the law does not allow you to impose those rules, and vice versa, by the way. So all those kinds of things may sometimes have an impact on what you as an employee or employer can do with respect to your intellectual property. What ideas, who owns the ideas, who can take the ideas elsewhere, even things like, for example, industrial espionage. I mean, that's just essentially a copyright thing, and so in some countries it would be very strictly enforced, and there would be very tight rules about that, and in some countries there may be none. And finally, ethics. Again, we talked about ethics in Management 301 with respect to, for example, things like, bribes to get contracts in different countries. As in some countries it would be completely illegal, and in other countries it's not only allowed, you would actually be able to deduct the amount or the cost of bribes from your taxable income as a company. In Germany, for example, up until 1997, companies could bribe officials in foreign countries to get contracts. And so Siemens was in trouble for that at some point, because in the United States you cannot do that, but the German law explicitly allowed that up until very recently actually. But then again, talking about the employment standards and laws, there would be all kinds of rules in different countries, or none, or there will be no rules in some countries with respect to nepotism, to what we call social capital, guanxi as they call it in China, or blood as they call it in, for example, Russia. There would be all kinds of rules about conflicts of interests, and so some of those would be kind of gray area. So hiring your relative, is that legal or illegal? Well, the law normally wouldn't have any rules about that. But then again, there would be some ethical standards. So in the United States, usually it's frowned upon. So the president, for example, couldn't have, let's say, his wife appointed the chief of staff. The law doesn't explicitly prohibit that, but it would be, from the ethical perception, unacceptable, and obviously such a policy would lead to an outrage. In other countries, it would be very, very common. In fact, in many countries like Belarus, like Ukraine, like Russia, I mean, literally some families would be ruling the country, and it would be not only legal, but people seem to be okay with that. So, and then obviously conflicts of interest. In the United States, we would think that it would be a big problem, but even here we see a lot of people moving between Wall Street and the White House back and forth, or Congress and the Wall Street. So they would get a government job and then they retire and go and take a job in the, so they would, for example, have a job that regulates certain industries, and then right after their retirement from the public office, they would take jobs in those industries, or vice versa. And so the conflict of interest, or possibility of conflict of interest, is obvious, and there are many people who complain about that, but even here sometimes those cases are here. In fact, they're very, very common. But then again, at least here there is some public discussion about the problem related to that situation, whereas in other countries that's perfectly normal and often, common. And then obviously bribes, both not only to get contracts for jobs, meaning contracts as for a company, but also employment contracts. And in fact, in some countries, and shame, but yes, it's the case that in my native Ukraine, it seems like getting a good job is impossible these days without a bribe. And in fact, the bribe amounts are pretty much fixed. Like for example, half a year's salary to get a job as a nurse at a hospital. One of my distant relatives actually had to go through that recently. Then obviously, feedback provision. So when you provide feedback to your employees, again, there may be very specific rules as to how you can provide the feedback, what you can say, what you cannot say, what kind of feedback the employees are entitled to. Again, all of those may not be explained in the law, but there may be some ethical standards as, can you criticize your employees in front of other employees? What information you should reveal? How frequently you should provide feedback? If there is a conflict, how it should be resolved? Usually those would fall within the ethics jurisdiction, so there would be no legal rules about that. And again, those will be very, very different from from a country to country. In some countries, it would be very formal, in terms of how you hire people, how you provide feedback, how you resolve conflicts. In other countries, it would be very, very hidden. It would be done all under the table or in the back room, and so the rules would be very, very different. Finally, again, where the law ends and the ethics begins, or vice versa, that boundary, that limit, that threshold would be different in different countries. In the United States, we tend to explain every possible situation in the contract or in the law. And so the contracts, the laws tend to be very thick, very detailed, notoriously detailed, and notoriously long. In other countries, there may be even no contracts at all, or if there is one, it would be very general, very simple. And so again, in the United States, there is not much room left for the ethics. Most of the stuff is described in the legally binding documents, whereas in some other countries, just about everything would be within the ethics realm. So about everything would be, our interpersonal understanding, not the actual legal document. Anyway, this is where we're going to stop. Thank you very much, and read the chapter for more information. Thank you.